We now proceed to the Equal Protection Clause. To a certain extent, everyone is similar, but to another extent, everyone is also different. How to make sense out of the similarities and differences is the function of the Equal Protection Clause. How do you try to draw the line so that you can treat people similarly or differently depending on the circumstances? And this essentially is all about classification. For the purpose of seeing to it that the classification would be reasonable and not arbitrary. One, there must be a substantial distinction between these classes. Then the classification must be germane or related to the purpose for which classification is being made. Also, must not be limited to existing conditions only. And finally, that it must be applicable to all members of the same class. Now let's talk about some cases in which classification was an issue. In Garcia versus Drilon, there's something to do with the claim by the husband that the law on anti-violence against women and their children, or Republic Act number 9262, is violative of the Equal Protection Clause. He claimed that there was a violation because it's only the women who get the kind of protection provided under the law. He said that men are also victims of domestic violence. So why should it be limited only to women when it comes to the protections afforded by the law? The Supreme Court said there's no violation of the Equal Protection Clause. It explained that historically, women have always been the victims of domestic violence. There is an ingrained societal prejudice against women. And even assuming that men could also be the victims of domestic violence, the frequency by which this happens does not go up to the same level as that for women. Therefore, it's the women that need the kind of special protection provided under RA 9262. In any event, the Supreme Court explained that if men become victims of domestic violence, they're not entirely without any remedies. They can still avail of the provisions of the Revised Penal Code or any other laws by which they could have some relief from domestic violence that they may have suffered. In regard to marriage and divorce, under the Family Code, particularly Article 26, divorce may be had for Filipinos provided that it is a divorce procured by their foreign spouses. So this would only be available to Filipinos who have foreign spouses. And under the literal language of the law, it is needed that it should be the foreign spouse who should secure the divorce and not the Filipino spouse. However, in the case of Republic versus Manalo, the Supreme Court said that if we were to read literally the law as written, it would be a violation of the Equal Protection Clause. Therefore, the court said it should be understood that when it comes to obtaining divorce, it should not make a difference whether it is the Filipino spouse or the foreign spouse who would be initiating the divorce proceedings. Otherwise, there would be an unfair difference between those Filipino spouses whose spouses would secure a divorce and those Filipino spouses who themselves would be the one to secure the divorce from their foreign spouses. The classification made by the law between these two types of Filipinos is superficial, arbitrary, and whimsical, the court explained. It doesn't really make a difference because Filipinos who are married to foreign spouses and who try to have divorce for reasons which are valid should be accorded the same right. So it doesn't matter whether it's the foreign spouse who would secure the divorce or it is the Filipino himself or herself who secures the divorce. In regard to qualifying examinations, we have that case of Tablarin versus Gutierrez regarding the NMAT or the National Medical Admissions Test. The contention here with regard to violation of the Equal Protection Clause is about the ever-changing passing grade. If one time the passing grade is 75, another time the passing grade is lowered to 73, and so on and so forth, the contention that's made is that this would be a violation of the Equal Protection Clause because the examinees are not treated the same way. What if somebody took the NMAT in a particular year, but the passing grade was 75, he got 74. The following year, he did not take the NMAT, but the passing grade was lowered to 73. So would it not be unfair to him if he took the NMAT at the time when the passing grade was 73, then he would have passed with his grade of 74. But the Supreme Court said, no, there's no violation of the Equal Protection Clause because you cannot consider one batch of examinees similarly to any other batches of examinees. It may happen that for one batch, there are many who took the NMAT. So there may be a need to maintain a high passing grade because there are only limited slots for medical students. At another time, there may be a few who took the NMAT. So you need to adjust the passing grade to accommodate more, to accept more who want to take up medical education. Or it might be that the examination questions were very difficult. And if you were to maintain a high passing grade, only very few would be able to make it to medical school. So you have to consider the different circumstances depending on each batch. You cannot equate them together. Another case involving the NMAT is Department of Education, Culture, and Sports versus San Diego, in which there is the so-called three-flunk rule. If you are interested in taking up medicine, you're only given 3 chances of passing the NMAT. If you fail after the 3rd try, then your medical dreams would already be out of the question. The claim on equal protection here is that it is only in medical education that you have this so-called three-flunk rule. The other courses do not have it. So it is not a violation of the Equal Protection Clause. The Supreme Court said, no, it's not. The court explained that even as it does not try to minimize the importance of other courses, it cannot be denied that the other courses, the other professions, are not as demanding as medical education. Because we have to remember that when those taking up medicine would become doctors, they would be constantly confronted with questions of life and death. And therefore, you need to have the best and the brightest when it comes to the study of medicine. In any case, the Supreme Court further explained, if you don't make it to medical school, it doesn't really mean that you are useless. You may be good in some other fields, but not when it comes to medicine. So if you don't make it to medical school, you can try some other courses. In regard to government recognition and awards, we have that case of Almario versus Executive Secretary with regard to the National Artists Awards. There's a process by which national artists may be chosen. So there may be nominees. Eventually, there's a process by which this initial list may be trimmed down to a short list. And it is from the short list that the president is supposed to make a choice as to who would be granted the National Artist Award. In this case of Almario, there was a short list that was submitted to the president, but the president, instead of limiting her choices to the list, gave the National Artist Award to some others not in the short list. The Supreme Court said this is a violation of the Equal Protection Clause because it is only those in the short list who are supposed to be in a position to be selected, to be granted the National Artist Award. But if the president chooses from outside the short list, she in effect elevated some other persons to the same position in which they did not actually belong. They were treated in the same way as the others who were supposed to be the chosen ones. So if that happens, when you try to make others go up to the same level, a situation in which they don't really belong, then that would be a violation of the Equal Protection Clause. In regard to elective and appointive officials, originally, if an elective or an incumbent elective official filed his certificate of candidacy for a position other than what he was holding, then he would be deemed automatically resigned from his position. That was also the effect in regard to those appointive officials. Subsequently, the law was amended. The automatic resignation effect was only retained insofar as appointive officials are concerned. But for elective officials, even if they filed their certificates of candidacy for a position other than what they were holding, they would not be deemed resigned. So the contention was made that this would be a violation of the Equal Protection Clause. Why are the elective officials treated differently from the appointive officials? The Supreme Court said there's no violation of the Equal Protection Clause. The court explained that there's really a substantial difference between elective and appointive officials. For elective officials, they only have a limited term of office. For appointive officials, they could theoretically stay in office until they retire unless removed for post earlier. For elective officials, they need to continually seek electoral mandate. For appointive officials, there is no such need. For appointive officials also, they're not allowed to participate in partisan political activities. So given these differences, which the court considered to be substantial, there is no violation of the Equal Protection Clause if you allow elective officials to remain in office even if they file their certificates of candidacy for some other elective position. In Biraugo versus Philippine Truth Commission of 2010, then Philippine President Aquino came up with an executive order creating the Philippine Truth Commission of 2010 with the specific mandate of investigating the alleged widespread graft and corruption during the past administration of GMA. The executive order was assailed on two grounds. One, with regard to the creation of the office. And two, violation of the Equal Protection Clause. With regard to the creation of the office, the contention was made that it's Congress that has the power to create offices. Therefore, the president does not have such a power. But the Supreme Court said, pursuant to the Take Care Clause or the Faithful Execution Clause of the Constitution, the president may create ad hoc offices to aid him in determining certain facts so that he would be guided in coming up with how to carry out the law. So the creation of the Philippine Truth Commission is considered to be within that prerogative of the president. However, when it comes to the equal protection issue, the Supreme Court said there was a violation. Why? The court explained that as a general rule, all previous administrations had been criticized for having been characterized with widespread graft and corruption. Therefore, the case of the GMA administration is just a part of that class. It belongs to a class that had been criticized for widespread graft and corruption. And yet, the executive order focused or singled out the GMA administration for investigation. So that is a violation of the Equal Protection Clause because it did not treat GMA administration similarly with the other past administrations. The violation could have been cured if the Philippine Truth Commission was tasked with the duty of going after all previous administrations which had been criticized as having or as being involved in widespread graft and corruption. But since it did not do so, then it was considered to be a violation of the Equal Protection Clause. We may have the requisites for a valid classification, but sometimes it's not that easy to apply. And even the justices themselves may not be in agreement as to whether those requisites have been complied with or not. A good example for this is the case of League of Cities versus COMELEC. This had something to do with the creation of or the conversion of certain municipalities into component cities. During the 11th Congress, there were several bills filed for the conversion of municipalities into component cities. Some were acted upon and they became laws. But at the end of the term of the 11th Congress, there were about 24 pending bills of the same nature which were not acted upon by Congress. So Congress passed out of existence but there were these bills which were not acted upon. At the time when these bills were filed, it was only required that they have at least 20 million pesos annual income. But during the 11th Congress, towards the end, it enacted an amendment to the local government code, increasing the income requirement from 20 million to 100 million pesos. And all of these municipalities with pending bills could not comply with the annual income requirement of 100 million pesos. During the 12th Congress, there was an attempt on the part of the House of Representatives to come up with a joint resolution to be passed by both the House of Representatives and the Senate, exempting these municipalities with pending bills at the time when the new law was enacted. But the Senate did not act on this intended joint resolution. The 12th Congress passed out of existence, and the following Congress came around. Again, the House of Representatives tried to come up with the joint resolution. But once more, the Senate was lukewarm to the idea of agreeing with the House of Representatives. So eventually, upon the advice of then Senator Pimentel, 16 of the municipalities with pending bills during the 11th Congress came up with individual bills with a uniform provision exempting them from the increased income requirement of 100 million pesos. These bills eventually passed both the House of Representatives and the Senate. They eventually became laws without presidential action. The president simply sat on them, and after 30 days from receipt of the bills, they became laws. When they became laws, that's the time when the League of Cities questioned the constitutionality of their creation. The League of Cities said that these bills did not comply with the constitutional requirement, specifically in regard to the income requirement. The court or the League said that at the time when they became laws, there was already the amendment to the local government code increasing the annual income requirement to 100 million pesos. Therefore, these municipalities should have complied with that requirement. And since they did not, then they did not validly become component cities. In the initial decision of the court in 2008, the Supreme Court said the petitioners are correct. There was failure to comply with the annual income requirement as set out in the local government code as amended. And the court further explained that the mere fact that they had pending bills at the time when the amendment became law was not by itself a substantial distinction which would have separated them from the other municipalities who similarly were unable to comply with the 100 million annual income requirement. The following year, the Supreme Court changed its mind. A new majority came about and said that the municipalities were validly converted into component cities. And the fact that they had pending bills at the time when the amendment to the local government code was enacted was sufficient, was substantial enough a distinction between them and those municipalities which had no pending bills. The year after that, a new majority once more emerged and it once more reversed the decision of the court the year earlier. It reverted to the original decision saying that the 16 municipalities could not have been validly converted into component cities because of failure to comply with the requirement. And that the mere fact that they had pending bills was not substantial enough to differentiate them from the other municipalities. The year following, the Supreme Court once more turned around. And this time, the court said, it's not merely the fact that they had pending bills at the time when the law increasing the annual income requirement was passed. This has to be taken also in relation to the fact that these municipalities with pending bills then were substantially different from the other municipalities in their areas. These municipalities were the centers of economic, social, cultural, and educational activities, which the other municipalities could not similarly claim. These municipalities with pending bills signified that they were willing to take their place in the development and advancement of the country, something that the other municipalities could not have also validly claimed. So this together would indicate that there was a substantial distinction between these municipalities with pending bills and the other municipalities which had no similar pending bills. And with that, the Supreme Court was able to validate the creation of these new cities. So you can see it took 4 years for the Supreme Court to finally determine whether there was compliance with the requisites for valid classification or not. In regard to equal protection, there is also the so-called under-inclusiveness argument. This may be made when somebody who assails classification would argue that Congress did not include more in a particular classification. Like the circle that it came up with is smaller than what it should have been. But the Supreme Court has invariably said that the under-inclusiveness argument is not a valid reason to invalidate a law on account of alleged violation of the Equal Protection Clause. Because Congress may start with something in the meantime, and it is not required of Congress to include everything that may be included in the first instance. So it may start with something small, and eventually it may come up with something bigger. But the fact that it did not include more initially is not a valid reason to say that there's a violation of the Equal Protection Clause.